Can an employer call us independent contractors just to dodge benefits and overtime? The short answer is no. The law decides, not the company. Misclassification is a common trick to save on payroll taxes, Social Security, workers' comp, and health coverage. But workers lose protections in the process. In this video, we'll break it down clearly. 1. What the law says about employee versus contractor status. 2. The tactics employers use to avoid paying benefits. 3. Real cases where misclassification backfired on companies. 4. What steps we can take if it happens to us. By the end, we'll know how to spot misclassification, why it matters, and how to protect ourselves. Let's dive in, because our paycheck and benefits shouldn't depend on an employer's label. What the law actually says. Under the Fair Labor Standards Act, FLSA, employees are entitled to minimum wage, overtime, and certain protections. Independent contractors, by contrast, don't get those benefits. That's why employers may be tempted to call us contractors, even when the reality shows we're employees. But here's the key. Employers don't get to decide on their own. Courts and the Department of Labor apply the economic reality test. Do we run our own independent business, or are we economically dependent on the company? Let's simplify. If the company controls our schedule, hours, and methods, employee. If we work only for them long-term, employee. If we use their tools, wear their uniform, or perform their core business tasks, employee. If we can negotiate rates, use our own tools, and serve multiple clients, contractor. The IRS also checks 3 areas: behavioral control, financial control, and the nature of the relationship. If the employer controls all 3, we look like employees. Employers who misclassify aren't just cutting overtime. They're avoiding payroll taxes, unemployment insurance contributions, and health insurance obligations. This shifts the burden onto workers and taxpayers. That's why the Department of Labor and many state agencies actively investigate misclassification. The message is simple. Our legal status comes from reality, not job titles. Even if the contract says independent contractor, the facts may prove otherwise. Tactics employers use. Let's talk about how employers try to get around the rules. Tactic 1, contractor agreements. Companies hand out contracts with the words independent contractor in bold letters. But the Department of Labor says paperwork doesn't override reality if day-to-day work looks like employment. The law treats it that way. Tactic 2, forcing workers to buy tools or vehicles. Employers may argue, you're independent because you provide your own equipment. But courts look deeper. If the company still controls routes, hours, and pay, ownership of tools doesn't erase employee status. Tactic 3, calling overtime flat pay. Employers might say, you're on contract, so no overtime. But if we're employees under the law, overtime is mandatory, no matter what the contract says. Tactic 4, shifting benefits. Some employers cut health insurance or retirement contributions by calling people contractors. This is a major red flag. Benefits aren't optional when the law says we're employees. Tactic 5, short-term labels. Sometimes a worker is told you're just temporary, so you're a contractor. But permanence is only one factor. If the job is central to the company and under its control, temporary doesn't mean contractor. Example, a warehouse hires independent contractors to stock shelves, but gives them schedules, supervisors, and uniforms. That's classic employee work, even if the contract says otherwise. These tactics may save employers money in the short run, but they create massive legal risks. When caught, companies owe back wages, penalties, and unpaid benefits. Real-world cases. Real cases show how serious this issue is. FedEx ground drivers. For years, FedEx insisted drivers were contractors. They had to buy trucks, but wore FedEx uniforms, followed routes, and worked full-time for FedEx. Courts ruled many were employees, forcing FedEx into multi-million-dollar settlements. Construction industry. Misclassification is rampant here. Contractors tell workers they're independent, but control hours, provide tools, and ban outside jobs. State labor boards have cracked down, recovering overtime and unpaid benefits. Gig economy. Uber and Lyft drivers are a prime example. In California, AB5 created the ABC test. Workers are employees unless the company proves A, the worker is free from control, B, the work is outside the company's core business, and C, the worker runs an independent trade. Driving passengers is Uber's core business. So under AB5, many drivers qualify as employees. Janitorial services. Cleaning crews are often told they're independent, yet they wear company badges, use company supplies, and follow strict schedules. Courts have ruled again and again they're employees. Statistics. Department of Labor Studies estimate that up to 30% of employers misclassify some workers. That means millions lose overtime, health coverage, and unemployment protections each year. The lesson from these cases is simple. If reality looks like employee work, courts will treat it as employment. Employers who misclassify face not only lawsuits, but also government fines and reputational damage. What we can do if we suspect misclassification. So, what can we actually do if we think our employer has misclassified us? The good news is there are several clear steps workers can take, and the law provides real protections when we act. Step 1. Gather the evidence. Before taking action, we need to build a record. Keep copies of contracts, pay stubs, time cards, schedules, and any company communications that show control over our work. Did the company assign shifts, require uniforms, provide training manuals, limit outside work? All of these details support an employee classification. Even text messages or app screenshots can become powerful evidence when proving how much control the company exercised. Step 2. Learn our rights under federal law. The U.S. Department of Labor's Wage and Hour Division enforces the Fair Labor Standards Act. Workers can file a confidential complaint if they believe they've been denied overtime or minimum wage through misclassification. Once a complaint is filed, investigators review records, interview workers, and examine how the company actually operates. If the agency finds violations, the employer can be forced to pay back wages, damages, and penalties. Step 3. Don't overlook state protections. Some states go further than federal law. California, Massachusetts, and New Jersey use stricter tests that presume workers are employees unless the company can prove independence. For example, under California's AB5 ABC test, a worker is an employee unless A, they are free from control, B, they perform work outside the usual course of business, and C, they operate an independent trade. That means a delivery driver working full-time for a delivery company is almost certainly an employee. Checking state law is essential because it may offer stronger remedies. Step 4. Consider legal representation. Many wage and hour lawyers work on contingency, no upfront fee. If misclassification has cost thousands in unpaid overtime, health benefits, or unemployment eligibility, an attorney can pursue recovery in court. Some cases even turn into class actions where entire groups of workers band together to challenge unfair practices. In those cases, settlements often include not just back pay, but also interest, penalties, and attorney's fees. Step 5. Speak up, but no, retaliation is illegal. Sometimes employers misclassify out of ignorance, not intent, asking, "Am I considered an employee under the FLSA or state law?" can start a conversation. But if the company reacts with threats, firings, or punishment, that's retaliation, and retaliation itself violates federal law. Workers can file retaliation claims, and employers found guilty may owe additional damages. Step 6. Stay informed and connected. Worker centers, unions, and advocacy groups often provide guidance, free clinics, and community support. Staying connected ensures we don't fight alone. The bottom line, misclassification isn't just a label problem. It's about fair pay, benefits, and protections. When we gather evidence, use legal channels, and stand firm, we can turn the law in our favor and hold employers accountable. So, can employers misclassify workers just to avoid paying benefits? No. They might try, but the law looks past labels. The FLSA, IRS rules, and state laws all focus on the reality of work. If we're under control, using company tools, doing core tasks, we're employees. Period. Misclassification cheats workers out of protections, but it also exposes companies to lawsuits and penalties. By knowing the rules, we can push back, claim back pay, and secure the benefits we deserve. If this breakdown helped, share it with coworkers who may be in the same boat. Let's stay informed, stay connected, and keep fighting for fair treatment together.